and welcome to this week's video blog on the law. In past video blogs, we've talked about reasons why people challenge wills. One of those reasons is the will was either prepared or signed as a result of interference or influence by another person. For example, the son of a testator might have pressured his parent to give him a larger portion of the family wealth because the son is the oldest child, or because his siblings are less liked or less successful than the son. The son might use psychological, financial, or even physical pressure to influence the decision of their parent in writing their will. In estate law, this is called undue influence. If a court finds the will maker was under undue influence when the will was prepared or signed, the court can cancel or reduce the gift to the person who applied the undue influence. Good or bad, when a person asserts a will is invalid because the will maker was under undue influence, they have to prove several things. Undue influence will not be found simply because the alleged influencer persuaded the will maker to make a change to their will that benefits that person. The influence must be sufficient that the testator's judgment or wishes were overpowered. Undue influence has been described as an influence causing the execution of a will which pretends to express the will maker's mind, but in reality does not, and expresses something else which he or she did not really mean. Therefore, mere persuasion or advice from an interested person will not suffice in proving undue influence. The heavy burden of proving the force or coercion destroyed the will maker's free will lies with the challenger. However, the burden of proof will shift if it can be shown that there was a special relationship between the will maker and another person who substantially benefits from a will. This is called the presumption of undue influence. This type of special relationship arises where the person was in a position where there was potential for dependence or domination of the will maker. This presumption can arise in a large variety of situations. A common example is where the will maker is a parent who is dependent on one of their children for their day-to-day care. Once this special relationship is established, it is the person who benefited from the will that has to prove that the gift was not made out of undue influence. If he or she cannot do this, the court can cancel or reduce the gift or even set the entire will aside. I hope you have learned something about the law from this blog. Please feel free to like us on Facebook, follow us on Twitter, or subscribe to our YouTube channel to receive notice of our future weekly video blogs on the law. Thank you.